Hello, everyone, and welcome to One Civil Law. And for today's story, we're going to do a bit of an update on the ongoing situation relating to the potential deportation of Mahmoud Khalil. Mahmoud Khalil was a graduate student at Columbia University who engaged in protests and may have done other things relating to that, a little bit unclear in terms of what he did or didn't do. But for the moment, not really particularly relevant because that doesn't seem to be the reason the administration is deporting him. They're not deporting him specifically because of any particular reason, but they're trying to deport him because, at least in the opinion of the Secretary of State, he is a threat to national security for somewhat unspecified reasons. And the Secretary of State believes their authority to make the determination is unchallengeable. So recently, as I'm sure many of you saw in the news, an immigration judge in Louisiana indicated that the deportation order can go forward. Now, as I think should be made clear, because you may not necessarily know this, immigration judges are part of the executive branch. They're not, they're administrative judges. So they're the executive branch. So an executive branch judge said the executive branch can deport based on a conclusion of the executive branch. So I know a lot of people might have seen this and be like, oh, the judge said things and like this person can be deported. Well, yes and no. The judge said it, but the judge is the administration. So there hasn't been a Article 3 court yet that has spoken to this issue. Just the administration speaking, you know, basically doing this. This is one administration. This is the other. Hey, I'd like to deport the person. I don't know. I don't know if you can do that. I really like to. Oh, okay, that sounds all right to me. Oh, I'm so glad we agree. It's nice that we work for the same administration, right? So just saying that, not particularly surprising. The administration judge said, "I agree with the administration." Just saying. In any event, we are still also proceeding in New Jersey relating to this in federal court in a parallel proceeding. And in earlier this month, the court refused to give up jurisdiction on the issue. So that's still proceeding as well. And of course, the immigration judge decision can also be appealed within the confines of the Department of Justice, but it's still the administration, so probably not going to get any joy there. But for the moment, I thought we could read what the federal court had to say on this issue. So we turn our attention to the United States District Court for the District of New Jersey in the case of Mahmoud Khalil versus William Joyce. And we're going to read over this and try to get through it and try to say what the court thinks about the issue relating to jurisdiction and other related issues. So this is a lawful permanent resident. This is a person with a green card, as we've mentioned before. And that status, at least, I think, may change the analysis. As I've said repeatedly, the fact that he has a green card may be relevant here. But yeah, anyways, it's a lawful permanent resident. And he's filed a habeas petition seeking his relief, which is one of the things that he can do. The respondent, various federal officials, have moved to dismiss, arguing the court does not have jurisdiction, but the motion is denied. The relevant facts are as follows for the moment. A lawful permanent resident was arrested by federal officials in Manhattan. While in custody, he was handed various forms. These said two main things. First, federal officials were seeking to remove him from the United States. He was given notice. And second, as part of that process, he'd be required to appear before an immigration judge in Louisiana in about 2 weeks. About 7 hours after his arrest, the lawful permanent resident's lawyer electronically filed a habeas corpus petition on his behalf in federal court in Manhattan. Okay, great. From here, the lawful permanent resident is called the petitioner, and his habeas petition is the petition. The petition names various federal officials. From here, they're collectively called the respondent. About 1 hour before the petition was filed on his behalf, the petitioner was moved to another detention facility. As a result, when the filing was made, he was no longer in New York, he was in New Jersey. So it's like, okay, you didn't file where you were, right? But they, of course, didn't know that at the time. So they filed in New York because they thought he was in New York, but he wasn't in New York. So it's like, okay, that doesn't work. The petitioner spent around 8 hours in New Jersey. From New Jersey, he was taken to Louisiana, where he remains today. So, okay, so this is procedurally is important, right? He was originally detained in Manhattan. So his lawyers filed for habeas in Manhattan. And the courts basically, and they're like, well, he's not here. You filed in the wrong place. He's in New Jersey. So his lawyers did a quick turnaround and filed in New Jersey. But they did manage to file in New Jersey before he was shipped off to Louisiana. He was in New Jersey at the time the lawsuit was filed. That's going to be important later. In the Manhattan federal court, where a petitioner had been filed, the response moved to dismiss. They argued the New York court did not have jurisdiction to hear it. The response core argument, habeas cases must generally be filed only in the judicial district where the petitioner is in question. We've seen that language from the Supreme Court. And the petitioner was not in New York when he was filed. At that point, he was in New Jersey. In light of this, respondent argued the New York court should either dismiss the case without prejudice, which will allow them to refile it in the right district, or transfer the case to the Western District of Louisiana, where the petitioner was confined. The petitioner made various counter-arguments, and the New York court issued two rulings. First, the court held that it did not have power to take up the case. This was plainly the corrected outcome under normal rules for habeas. The court determined because the petitioner was no longer in Manhattan where the federal habeas court was filed. He was not in Manhattan at the time they filed for the relief. And second, the court turned to deciding between dismissing the case and transferring it. The court took to transferring it, particularly New Jersey. Why New Jersey? Because certain statutes tell the federal courts where to transfer cases that are improperly before them. One of those statutes directs the court to transfer such a case to where it could have been filed. Okay, so in this case, it wasn't his lawyers who filed in New Jersey. It was the court who transferred it to New Jersey. It's like, no, you filed it in the wrong place, but I'm going to help you out. I'm going to transfer it into New Jersey, and then it's treated as though it was filed in New Jersey the whole time. So you get to basically backdate this thing. It's like, fine, cool. All right, so that's what we did. All right, cool. So the court in New York transferred it to New Jersey. At the moment the petition was filed, that's when the original petition was filed in New York, there was only such one place, New Jersey. So that makes sense, right? It's like, yes, at the time you filed this petition in New York, he was in New Jersey. You should have filed in New Jersey. Now I could dismiss and have you refile, but I'm just going to help you. I'm just going to help you out. I'm just going to transfer it to New Jersey. And great. And thus it happened. And now suddenly we're in the District Court of New Jersey. Huzzah. Right? Huzzah. No problem. Great. Moving on. The respondent has now moved to dismiss the case on arguments the court lacks jurisdiction. This motion has been fully briefed, and the motion is before the court. After brief discussion on relevant general principles, the court takes up petitioner's first argument. Respondent's motion must be denied in light of the New York court's transfer here. That argument, the court concludes, is not persuasive. The New York court decided that it did not have jurisdiction. It did not pass on whether New Jersey had jurisdiction. That question is therefore open, right? So all New York determined was it didn't have jurisdiction. It didn't determine anything about New Jersey. And presumably it thought New Jersey might have jurisdiction, otherwise it wouldn't have transferred there in the first place. It's because that wouldn't have made any sense. Under habeas law, okay, the court then directly considers whether it has jurisdiction. The court concludes it does. Under habeas law, jurisdiction in a particular district is established when a petitioner is physically present in the district at the moment the petition is filed. That confluence happened here. Petitioner was in custody in New Jersey as of March 9th at 4:40 a.m. And under federal statute, the petition, though filed in New York, must be treated as though it had been filed in New York on 4:40. Therefore, it has jurisdiction. And the court's going to get into this in a little bit more detail. So, right, we're just transferring it. We didn't dismiss it and refile it, in which case we'd get a new date. We transferred it. So the same date matters, right? It was filed on March 9th at 4:40 in the morning in New York, and now we're just going to cross out New York and write in New Jersey, same time, same date. Cool. The court then asked whether it lost jurisdiction to obtain. It obtained on March 9th because the petitioner was moved. The court's jurisdiction concludes has not been lost. The Supreme Court has all but so held. So it's like, no, despite the fact he's no longer here now, he was here. And so I have jurisdiction over the prisoner because he was here at the time. Okay. Finally, the court asks whether the jurisdiction it obtained on March 9th is undone because the petition did not name Louisiana or New Jersey. These omissions do not defeat jurisdiction. As to the Louisiana warrant, this is because the effect of an on-point Supreme Court case. As to the New Jersey warrant, this is because there's no way for the petitioner to know they were in New Jersey. So I didn't name either of the New Jersey or Louisiana wardens, because how was I supposed to know? I could have. But, no problem. We can help you out with that too. And then the court's going to get into that reasoning why. All right, so here's the relevant law. This opinion and order generally lays out the law on a given topic as it becomes relevant, but two legal principles come up frequently, so they're best sketched out here along with some of the connections to the case. The first issue is a habeas corpus petition must generally be filed in the judicial district where the habeas petition is physically present, as we've seen from the US Supreme Court, including in a case like 2 weeks ago. So, yeah, that is true. Recall that when the petitioner was in custody, he was in New Jersey at the moment he was filed, and now he's in custody in Louisiana. The second legal principle, habeas corpus petition like this one, that challenges custody imposed by Immigration and Customs Enforcement, a federal agency referred to hereon as ICE, must generally name as the respondent the warden of the detention facility in which they're named. That's typically how you do a habeas. You're suing literally the warden. Why are you holding me, warden? That is how a habeas is done typically. The petitioner here did not name the warden of New Jersey, though he seeks permission to do so. Okay. This district, okay, and the petitioner here did not name the warden of Louisiana, but he is not asked to do so. With these clear legal principles in mind, we now move on to consider the case. Law of the case. The petitioner's first argument is that the respondent's motion to dismiss must be denied without considering whether it's persuasive. The New York court, the argument goes, has already ruled on the relevant issue. Yeah, that doesn't make any sense. First, the premise is inaccurate. The New York court did not rule on the issue that this court needs to take on. Therefore, law of the case doctrine is not on the table. And second, even if the doctrine might have a role, the court would not opt to apply it here, which also sort of makes sense, incidentally, because district courts always have the power to reverse their own rulings, right? And we're still in a district court. So the law of the case doctrine doesn't really make sense because, you're still in the district court and they can always change their own rulings. So law of the case, yeah, that doesn't seem to make sense. Taking these points up as a moment after a quick look at some general legal principles. The starting point here is one of the law's recurring questions. How should the court weigh an earlier judicial decision? That's a good question to ask. Different bodies of different legal rules, each tailored to a different circumstance, supplies answers. Stare decisis is an example. Res judicata is another. Right? Stare decisis is basically, because we held it in one case, it remains for all cases. That's stare decisis. Res judicata is your case was decided and that decision continues to impact you. So you can't just go file off in another court. Once a district court, kind of disposes of it, that, and you didn't appeal, you can't just refile, even if you could have filed somewhere else in the first place. You had your chance and, res judicata bars you. One of these bodies of rules is the law of the case doctrine. Under that doctrine, when a court decides upon a rule of law, that decision should continue to govern the same issues in subsequent stages of the same case. So this also deals a lot with if cases are going back and forth between the Court of Appeals and backwards, right? So, if it goes up to the Court of Appeals and then back down, right, that law remains on the case, right? Because it impacts the case regardless of what impact it might have on other cases. So it continues to permeate your case because we don't, once an issue's sort of been decided, that kind of gets, if you appeal that issue for some reason, that gets decided, that's now, you can't revisit that at the district level, that's for sure, because the Court of Appeals has spoken, right? Law of case doctrine may apply whereas here a litigant asks a federal court in one district to defer in some way to a ruling of a federal court in another district already making in the case. But the doctrine kicks in only when the two courts have resolved the same issue. That means the doctrine does not apply when the first judge never decided the first issue. Right. If the first judge didn't rule on it, then there's no rule of the case. How could there be? When the doctrine is in play, it's discretionary. That means a court generally has the choice. It can opt to go with the earlier decision, or it can reflect on the previous decision and, if necessary, take things in a different direction, informed by the prior decision, but not entirely hemmed by it. For basically the same reason that a district court can reverse itself. Right? District courts don't necessarily like to reverse themselves. It's not their favorite thing to do, but they can. And so, if they make a mistake, the district court can change its mind, even if it was a different district court, because they're of equal power. All right, come back now to this case. Petitioner's argument is that under law of the case doctrine, New York court's decision requires the court to deny respondent's current motion to dismiss for lack of jurisdiction. But the argument is not persuasive. The reason why? The issue that was resolved by the New York court is not the same as the issue on the now pending motion to dismiss, and so law of the case doctrine is not part of the mix. To see the point, start by zeroing in on what the New York court did, and then look at the question now before the court. At its core, the New York court held that it did not have jurisdiction over the case and that it would transfer the matter to New Jersey. Why New Jersey? The New York court looked mainly to a 1948 law that covers court-to-court transfers. Under the relevant law, a federal court with a case that's been filed in the wrong place has two choices. It can dismiss the case, or it can transfer it to any district in which the case could have been brought. So federal law explicitly allows the district court to do this. So no problem. The district court's not inventing this up. It's like, it's up to you. Which of these options do you like better, district court? Cool. Per the New York courts, section 1406.2 New Jersey, at the moment the habeas petition was filed, the petitioner was in custody here. And as noted, a habeas petition can be filed only in which the district in which the person was detained. Therefore, the New York court concluded the case could have been brought in New Jersey and would be transferred here. Now compare that to the issue before this court. The issue is the one put by the respondents in their motion to dismiss. Does this court in New Jersey have jurisdiction over this case? Did the New York court make the determination about this court's jurisdiction? The petitioner seems to say yes. For example, petitioner takes respondent to task for arguing that this court must reevaluate its own jurisdiction because New York court got that question wrong. But wrong or right, the premise of the argument is that the New York court assessed this court's jurisdiction, which it didn't do. It didn't conclude it. But subject to an exception that takes place, and even if it had, the district court can't possibly bind the other district court. That doesn't make sense. But subject to an exception taken up below in footnote 14, there's nothing explicit along those lines in the New York court's decision. For example, the critical argument from respondent in New York was that habeas jurisdiction never vested in New Jersey because petitioner did not file a petition here. And the respondent argued the federal transfer statute cannot fill the gap because they do not independently vest the court with jurisdiction. Well, I mean, that's true. The transfer statute does not jurisdiction make. That is 100% true. That is 100% true. If the district court transferred it to another district court that didn't have jurisdiction, the transfer itself does not grant jurisdiction. In the same exact way that filing there alone does not grant jurisdiction. Maybe you just filed in the wrong place. Maybe the district court transferred it to the wrong place. So the transfer itself is not a jurisdiction creating statute. It does not create jurisdiction. You need another reason to have jurisdiction than that. No problem. I understand that completely. But these questions were not addressed in New York court's opinion. There was no discussion, for example, as to whether one court could potentially take habeas jurisdiction on a derivative basis based on an earlier finding in another court. And there was no discussion as to whether there's a federal statute that vests jurisdiction the respondent said was missing. These are not gaps in the New York court's analysis. They are rather indications of what the analysis was about. The New York court opined as to its own jurisdiction. That's all it did. But it did not purport to rule as to this court's jurisdiction. Of course it does. It's a different district. It has different issues. No problem. Moreover, there's strong affirmative indications that the New York court did not see itself as resolving the court's jurisdiction. Look to one in particular. To see it, start by noting that in the Supreme Court's Padilla decision, Justice Kennedy suggested in a concurrence that certain wrongs of wrongful behavior from the United States, like hiding a detainee's location, might confer habeas jurisdiction on a particular court, even one that might not otherwise have power. So if we don't know where you are, maybe we have to guess, and maybe that's okay. The New York court did not decide whether to adopt for itself this concurrence, but it determined that even if the concurrence might be on the table as a general matter, the actions of federal officials in this particular case would not trigger it. In reaching this conclusion, the New York court put aside any question as to federal officers' conduct relating to the petitioner's transfer. These questions, the New York said, was not jurisdictionally relevant. And that makes sense. Any potential downstream misconduct by federal officials and sending the petitioner from New Jersey to Louisiana could not impact whether there was or was not jurisdiction in an earlier point in New Jersey. I mean, how could it possibly? You can't go back in time as to like factual issues, right? I mean, so either the court had jurisdiction in the past or it didn't. You know, if whatever the administration did in transferring this guy around can't change whether a court had jurisdiction in the past. That doesn't make any sense. Such an inquiry, of course, might shed light on whether there was jurisdiction in New Jersey, but no analysis like that was conducted. The New York court suggested such an analysis would be jurisdictionally irrelevant, and with good reason. It was indeed irrelevant to its question, whether there was jurisdiction in New York, even as it might have well been relevant to the question it was not addressing, is there jurisdiction in New Jersey? Nor is it surprising in any way that a New York court transferred case without first deciding this court had jurisdiction. Courts routinely transfer cases on the understanding the transfer court will itself determine jurisdiction in the first instance, because of course they will. Why wouldn't they? Why wouldn't they make that decision for themselves? And then we cite a whole bunch of cases. And then there might have been a special reason to proceed that way here. To decide there was no wrongful conduct in New York, which may have been relevant to jurisdiction, the New York court leaned on its understanding of how ICE handles cases every day in New York. That understanding was based on the extent to which the New York judge's own direct experience with ICE. How does New Jersey ICE operate? The New York court may well have thought the question was best considered in the first instance by New Jersey. I mean, fair enough, right? ICE is, of course, an organization with lots and lots of people, and the way that they do business in Manhattan may not necessarily be exactly the same way they do business in New Jersey, or at least the judge's experience with how they do business in New Jersey. So, fair enough. Audio's glitching pretty badly. Is it really? How is it glitching? In what way is it glitching? I'll wait. It sounds fine. Great. Moving back. It was bad, but it's fine now. How long was it bad for? Do I need to redo the entire stream? How big a problem is it? It was clipping. It was fine to begin with. It's fine. Like a second? Okay. If it was only for a second, I'm not going to restart the stream for that. All right, fair enough. All right, pressing on. We'll blame YouTube for that one. More generally, the New York court might have thought that determining what happened to the petitioner in New Jersey could bear on New Jersey jurisdiction, but that any necessary fact gathering on that point should go forward to where the case happened. And one last point. The Third Circuit has repeatedly made clear that in law of the case context, that the question of what one court decided is assessed in part with reference to the issues that were teed up for the parties. In United States versus Curtis, for example, the Court of Appeals declined to infer that the first court's rejection of the argument the parties had not meaningfully raised in court, in the absence of some judicial statement that the contention had been considered and rejected. And look too to Fagan versus City of Vineland. There, the Third Circuit held the first judge had not considered a particular issue, in large part because the motion papers before them did not dive into it. Against this backdrop, it would make little sense to conclude that New York court held itself that this court had jurisdiction, even as petitioner himself did not substantially make that argument in New York. The petitioner's initial opposition brief mentioned going forward in New Jersey, but only as a fourth fallback. The petitioner's argument to keep the case in New York, or if not, allow jurisdiction discovery, or if not, allowed to amend. And if all else failed, the petitioner argued the case should be moved to New Jersey instead of Louisiana. None of this teed up a serious reckoning with the distinct legal complexities associated with this court's jurisdiction. And none of those complexities were discussed in the petitioner's opening brief, which cited none of the key authorities that are relevant to New Jersey jurisdiction. There was, for example, no discussion from petitioner of relevant law. And when the New York court followed up with a directive for further briefing as to the import of these particular statutes, there was more of the same. New Jersey jurisdiction was not substantially put forward as an issue by the petitioner. Yep. The petitioner suggested that venue was proper in New Jersey and did so largely by leaning on arguments from the locations of witnesses, lawyers, and parties. But this argument from the petitioner simply invited the New York court to do what it did, to transfer the case on convenience type grounds, which is another issue, right? So convenience is yet another issue. So if multiple courts have jurisdiction, one of the things that a court could choose to transfer a court case to would be for convenience of the parties. So like, where are the witnesses, or where is the evidence, like physically, where is it physically being held, that kind of thing. So if jurisdiction exists in both, say, Alaska and Florida, hypothetically, and all the witnesses and evidence are in Florida, and you sue in Alaska, the Alaska court's probably going to say, you know what, I know that I do have jurisdiction, and I know that this technically is a proper venue, but you know what? How about still no? How about everyone goes to Florida, because that's where the evidence and witnesses are. Thank you for visiting our great state of Alaska, but I'm going to take a pass. So that's definitely a thing that can happen. This is a different guy that was deported. This guy has not been deported yet. This is a different guy. All right. And this, the case shows, is an everyday approach to transfer. A finally related piece of petitioner's papers helps to make clear the question of New Jersey's jurisdiction was far removed from how this case was litigated in New York. New York court, as noted, sought analysis to 3 statutes. In response, the petitioner said these statutes use almost identical language. For me, this issue is a lot easier than this court is making it out to be. This feels like a lot of words on not the easiest basis for me to solve the problem. I'm just saying. I'm like, you're a district court, and I'm a district court, and you're not the boss of me. You can't make me. Screw you. Right? It's like I'm really super thrilled about whatever the federal judge said in New York. And maybe I want to do those things. Maybe those things please me, but you can't bind me. You can't force me. How could you possibly force me? You're a district court. I'm a district court. What authority do you have over me? Suck it. But the court didn't write that. They wrote many other words instead of that, but whatever. Thank you for the kind compliment about my weight. It's appreciated. Progress continues. Every single day we make progress. One victory at a time, man. One victory at a time. But the third statute uses quite different language than the other two. And the difference is perhaps the single most important piece of the New Jersey jurisdiction analysis to come. But the petitioner did not note the language for the New York court, apparently because it did not matter for the argument he is making, an argument to transfer us to convenience, not to New Jersey's jurisdiction. Bottom line, the New York court decided it didn't have jurisdiction, but not that this court does. Yeah, and even if it had decided that, how could it possibly bind me is still the issue I'm wondering. How could the New York court, making a decision that my court has jurisdiction, possibly bind me? We're on the same level, man. You're not my big brother. Screw you. To finish out the analysis, go one step further. Was the issue of New Jersey's jurisdiction somehow taken up implicitly by the New York court? At 1 or 2 points, the petitioner appears to argue the New York court's transfer decision necessarily implied this court has jurisdiction. That's certainly what the New York court thought. But yeah. That argument, if it's being made, seems to start from the New York court's ruling that the case could have been brought in New Jersey because petitioner was the state at the moment. And that's certainly true as to what the New York court held. From this starting point, the petitioner's argument seems to be this: because this case could have been brought in New Jersey as opposed to New York, it follows that this case should be treated as though it was brought in New York that moment it was filed. And because of that, this court now has jurisdiction. Well, you're right about most of that. You're right about most of it. We will treat it as though it was filed in New Jersey the entire time. But jurisdiction is actually an issue that has to be reevaluated constantly, or it can be reevaluated constantly. If a court lacks jurisdiction, You know, you can raise that issue at any time. You can raise that issue on appeal. I've seen the US Supreme Court do it and be like, oh, this district court never had jurisdiction the entire time. And the entire case goes poof. I've seen it happen, right? Like 8 years of legal decision just go vanish like they never happened. Because the Supreme Court said, oh, no, we're determining for the first time this court never had jurisdiction. Poof, everything disappears. Thanks for 8 years of work. It all goes away. So, I mean, I'm just saying, man. I'm just saying. You love to watch Talk Today? I did too. It was pleasing to me. Thank you. Thank you for indulging me on my hobby. Much of this argument might well be persuasive in the end. Indeed, part 4 of the court's opinion explains that why this is sound. And part 6 of the court's opinion explains why the progression from B to C also makes sense. But these issues are not addressed in the New York court's opinion. Maybe, though, the conclusions reached in this opinion were logically necessary, though, and thus implicitly baked into New York transfer. But this only works if the New York court decision, the above necessarily leads to B, and then necessarily leads to C. But it doesn't go that way. The first step in the ABC progression is the move from saying A could have been brought in New Jersey to concluding, therefore, it should be treated as though it was brought in New Jersey. But A to B is not necessary, not in logic and not in law. Yeah, I mean, because the court had another option. It could have dismissed it outright. To see the point, start by imagining a student who turns in a math assignment late. She could have done her homework on time, but this does not mean her late work must be received by the teacher as though it was handed on time. What could have been done sets the table for another question, but it does not answer it. Or think of the train passenger asking the conductor not to charge him the extra $5 penalty fare, the step-up fine imposed for buying a ticket on board the train instead of back at the station. The passenger will not argue to the conductor he could have bought the ticket in the station. That's not a winning argument. Why? Because the fact could have bought the ticket earlier does not compel the conductor to give the passenger a break to treat him as though he did buy it. In short, there's typically real daylight between what could have been done and what was done. Sometimes that daylight may be closed up. The late homework might be accepted as if it had been submitted on time. The conductor might say no problem and not charge the $5 penalty. But none of that changes the basic point. Saying that a thing could have been done does not inevitably lead to the conclusion it should be treated as though it were done. Yeah, I mean, that doesn't make any sense on any level, right? And what's true as a matter of common sense is true as a matter of habeas law too. Although, of course, common sense doesn't necessarily always apply in law. So, be careful when applying common sense in law. In the Supreme Court's Padilla case, for example, a prisoner was held in New York and then transferred to South Carolina. Only after the transfer was the habeas petition filed on his behalf in New York. Could the petitioner have been filed for the person while he was in New York? Yes, if so, there would have been jurisdiction there. But that possibility as to what could have happened did not answer whether the New York court had jurisdiction over the case. Indeed, the Padilla court discussed this point at some length and then held the New York court did not have jurisdiction. In short, where the case could have been going forward, New York did not determine which court, North Carolina or South Carolina, New York or South Carolina, had power over the case. Take another example. In Al Marie versus Rumsfeld, a person detained in Illinois, believing he was being moved to military custody, asked to stay his transfer to time to petition for habeas, but he was transferred before he could file his petition. Per the Seventh Circuit, the question of whether the petition could have been filed in Illinois before the transfer did not answer the jurisdiction question as to whether it was vested in Illinois. After the United States filed its motion to dismiss the indictment in the Central District of Illinois, his lawyer orally opposed any movement of the individual until we had an opportunity to file a habeas corpus action, I suspect. We'd ask this court to stay his removal from the jail for at least until some time tomorrow, so we have an opportunity to file an appropriate petition with the court in regards to transfer to military custody. The district court denied the motion. According to Al Marie, asking the district court for an injunction against transfer was equivalent to filing a petition. What the hell? And such a petition had been filed while he was still in custody. That would have allowed the court to exercise jurisdiction. But what actually happened, basically, wishes are not horses. I mean, you could have done a lot of things in the past. We all could have done a lot of things in the past. Maybe we should have done those things in the past. But it doesn't necessarily make it so. Time travel, still not invented. Or maybe it has been. Or maybe it will have been, in which case is it invented now? That's a time travel paradox question I'm not going to resolve right now. Let's press on before my brain explodes. But what actually happened rather than what could have happened governs. Someone who files a notice of appeal one day after time expired loses, if the notice could have been filed on time. Likewise, with the complaint filed one day after the statute of limitations, or someone attempted to be served in hand one day after the potential defendant left the jurisdiction. What did happen after arriving in South Carolina after he filed the petition in Illinois? Accordingly, the Seventh Circuit held the habeas corpus case could not go forward in Illinois. In a nutshell, the New York court opinion might be understood as implicitly holding this court had jurisdiction over the case, only if New York holding necessarily required the conclusion that New Jersey had jurisdiction. It did not. Padilla and Almarie show that where a case could have been filed does not answer the question of whether it should be treated as having been filed there. Where things stand. This feels like a lot of words to get to the point. I know some courts can be long-winded, but holy shit, man. I felt like we could have gone to the point earlier. Although I'm one to talk. Me criticizing a court for being long-winded as though I'm not long-winded and repetitive sometimes. Pot meat kettle, baby. Pot meat kettle. The issues raised here of response motions where this court has jurisdiction. That issue is not resolved by the New York case. And it does not work to argue the New York court somehow implicitly held this court had jurisdiction. That runs afoul of Padilla and Almarie. All this means that law of the case doctrine does not come online here because law of the case operates only to limit reconsideration. And then I feel like we could have skipped all that analysis completely. I feel like we could have just said, okay, sure, it's law of the case. Fine, let's take it at a given in one sentence and just moved on to part D. So all part C was unnecessary, but whatever. As noted, the law of discretion doctrine is discretionary. So why do we spend so much time discussing it, right? And even assuming arguendo that the doctrine could be taken to apply here, based on some aspect of the language or implicit logic, this court would use its discretion not to invoke the doctrine in its case. This explains why. One of the bases of law of the case doctrine is to promote finality and efficiency of judicial process by protecting against agitation of settled issues. When time is invested, attention was focused, and decision was made, the ball should stop bouncing. An issue then should have been resolved and in its rear view mirror should be left there. I feel like we're mixing a lot of metaphors. Bouncing balls in rear view mirrors and... Okay. When time was invested, attention was focused, and a decision was made. Okay, but none of that's true here. The relevant question, does this court now have jurisdiction, was not substantially addressed by the New York court. This is not clear. The decision was made bar. Moreover, the question of this court's current jurisdiction can hardly be chalked up as having been the rear view mirror. The response made clear in New York, saying that if New York court opted to transfer this case to New Jersey, they would raise here the question of whether the court has jurisdiction. In short, if the court were to assume arguendo, the law of the case doctrine applies here because the New York court focused on the same issue, this court would exercise its discretion not to apply the doctrine because of unusual circumstances, because of three more things discussed below. Oh my God. Are you worried about being reversed on this? I mean, I don't think if you're going to be reversed, it's because of this reason. But I mean, okay, you do you. First, the law of the case doctrine appears to nip delay in the bud by preventing an issue that was considered before being litigated again. And more pointedly, the place of trial should not remain unsettled for an unreasonable long time to accommodate double judicial consideration. Cases need to get off the ground. But those concerns do not loom large here. A double look is not happening here. The New York court ruled on its own jurisdiction, and this court today rules on its own. I never want to be told I'm repetitive ever again. I never want chat to ever say I'm repetitive ever again. I learned by watching this. I learned by reading too many. And there's been no unnecessary delay. The New York court ruled 10 days after the habeas petition was filed. This court rules today on the second business day after oral argument. Second, law of the case doctrine rests on the idea that it's for the judicial department to say what the law is. This duty falls to the judiciary as a whole, and there's no reason to think one judge is somehow better at it than any other. The law of the case doctrine reflects this idea by telling the second judge to respect the first, who said what the law is for the case and whose determination should generally stand. But again, none of that's at stake here. On the point of New Jersey's jurisdiction, there's not yet been a sustained statement as to what the law is. Third and finally, courts routinely hold that judges are significantly less constrained by law of the case doctrine with respect to jurisdiction. I would think, and that principle applies with special force here, especially on potentially complex question. It does not make sense to allow either a very short statement or an implicit ruling to take the place of directed and detailed analysis. Jurisdiction is the first and fundamental question and should be taken head on and fully before it's determined whether this court has jurisdiction. Conclusion. The law of the case doctrine does not apply. This is because the issue here is where this court has jurisdiction, and that same issue is not taken up in New York, not even implicitly. In addition, even assuming arguendo, there's some way in which the same issue was reached and resolved, law of the case is discretionary, and we choose not to apply it here. I feel like we could have just said that in one sentence and called it a day, but no. The petitioner's law of the case argument aimed to cut things off at parts, but was not persuasive. Comes now to the substance of response motion to dismiss for lack of jurisdiction. The argument in the motion rests on is impact below, and the court explains why it doesn't work. So after going to some length to say, okay, we actually have to consider whether or not we do have jurisdiction, let's consider whether or not we have jurisdiction for a while, okay? The respondent's argument can be put this way. A habeas court has jurisdiction over the case when it has two things at once. First, it must have the habeas petition. And second, it must have, in its district, the habeas petitioner. The New York court sent this petition in New Jersey on March 19th. But by that time the petitioner arrived in New Jersey, the petitioner was gone. He's Louisiana. At no moment then was the petition and petitioner together in the same place. So that's even more interesting. So it took time to transfer it to New Jersey, and it still didn't arrive there even when the petitioner was there. This game of musical chairs is the worst game ever, man. When petitioner was here, the court lacked the petition, and now the court has the petition, the petitioner is elsewhere. The petitioner and the petitioner missed each other, and so the argument goes there's never been jurisdiction. Therefore, it makes no difference that New York court moved the case here on March 19th, because the case could have been or might have been brought here on March 9th when the case was first filed and petitioner was physically in New Jersey. Why does the transfer make no difference? Jurisdiction is missing because the petition and the petitioner were never together here, and the Supreme Court in Padilla required. And the transfer statutes do not purport to provide jurisdiction. They certainly don't in and of themselves. On respondents' argument, the transfer statutes are like conveyor belts, smoothing the way for cases moved from one district to another. But they are not like time machines. They do not allow a petitioner that arrived in New Jersey on March 19th to be treated as if it had arrived on March the 9th, the moment was filed in New York, and also the moment where petitioner was here in New Jersey. He was in New Jersey on March 9th at 4:40. He was in New Jersey then, but not on the 19th when the petition arrived in New Jersey. So which date now do we have to apply? And unless the petitioner can somehow backdate and thought of as being in New Jersey on March 9th, when petitioner was last here, there's no moment when petitioner and petitioner were together. Therefore, there would be no habeas. Great. Okay, fine. So can we backdate the petition? It arrived on March 9th. Can we backdate it? Can we say March 9th? Or it arrived on the 19th. It arrived on the 19th. Can we backdate it and say, no, it really arrived on the 9th? Can we do that? Let's find out. The problem with this argument is that it does not accord with the law. The relevant statute is from 1982 and it's entitled Transfer to Cure Want of Jurisdiction. And here is the relevant statute. Whenever a civil action is filed in a court, and that court finds there is a want of jurisdiction, the court shall, if it is in the interest of justice, transfer such action to any other such court in which the action could have been brought at the time it was filed or noticed, and the action shall proceed as if it had been filed in this court to which it was transferred on the date upon which it was actually filed in the court from which it was transferred. So yes, you can in fact backdate it because Congress said so explicitly. It's in the statute. Huzzah, right? Huzzah. It's in the statute. Congress literally wrote those exact words. Yes, when you transfer it from one jurisdiction to another, what applies is the date of the transferor, the transferor's jurisdiction, the original jurisdiction. So yes, it was March 9th the entire time. It's been March 9th for 10 days. This is fun and exciting. The statute is a command from Congress. Its language is clear. It tells the court to receive the transferred case that it must treat the court, shall proceed, I mean, it's mandatory, as if it had been filed the court to which it was transferred at the time in which it was first filed in the transferor court. In other words, when the law is in play, it does indeed work as a time machine. So Congress invented a time machine. How nice. How nice. It invented a time machine. Excellent. If Section 1631 applies, its import for this case is unmistakable. The petitioner arrived in New Jersey on March 19th, but this court, per the relevant law, shall proceed as if the petition got here when it was filed in New York, which was March the 9th at 4:40. At that moment, the petitioner was New Jersey, so there's no missing piece. Under the relevant law, the petition counts as having been in New Jersey at the same time the petitioner was. The key question is this: does the relevant law apply to this case? And does it have the effect? Yes and yes. The sections that follow explain why. I mean, I feel like you just explained why. You literally just quoted the statute. But sure, explain why some more. In transferring the case, the New York court relied on various sections of law. Does that mean this court should not rely on a different section of law? No. In Zhu versus DHS, for example, the Third Circuit preserved the timelessness of the issue by deeming it transferred under Section 1631, even though the district court had not used that statute, but rather had dismissed the case. And before that, on another occasion, the Third Circuit had come to essentially the same conclusion, that a transferee court can invoke Section 1631, even though the transfer court did not. And every circuit court to have decided the issue seems to have landed in the exact same spot. In short, the court can and does look to Section 1631 here. The fact that New York court did not invoke it as a basis for transferring the case does not matter, as every circuit to consider the question has suggested. Excellent. That was easy. Excellent. Per section just above, the court can look to Section 1631. But does that apply in a habeas case? Yes, Section 1631 applies to any civil action filed in the district court, and a habeas proceeding is civil. Thanks for clearing that up. In accordance with this, the Third Circuit has repeatedly recognized that Section 1631 applies to habeas, and so have other courts across the country. Section 1631 applies to habeas cases in general, but does it apply to this habeas case? It does. The statute's effect on the transferee court is mandatory, but only in two circumstances. First, where the transferor court finds there was a want of jurisdiction, and second, where transfer to another court is in the interest of justice. Here, each box was checked. The New York court determined there was want of jurisdiction, and it held the transfer was in the interest of justice. Fantastic. So if it was transferred for another reason, like, just convenience, then maybe not with the backdating. Okay. To this point, this court has established that it can look to Section 1631, even though the New York court did not invoke it as a basis for transfer. And the relevant law applies to habeas petitions in general, and to this one in particular. Section 1631 is in play. What then does it do? The court really likes rhetorical questions, doesn't it? See what I just did there? The words of the statute make clear that it cures jurisdictional defects. It tells the transferee court that shall treat the case as having been brought there in the transferee court at the moment when it first initiated the transfer court. But what kinds of jurisdictions can be transferred? This is not my preferred writing style. I find this writing style somewhat tedious. A leading treatise has suggested that 1631 focuses only on subject matter jurisdiction cures, but that is not the better view. To see why, start with the text and end with it. If the text be clear and distinct, no restriction upon its plain and obvious import ought to be omitted unless the inference be irresistible. Section 1631 says a cure of a want of jurisdiction. Had Congress wished, it could have said, for instance, that the statute would cure a want of subject matter jurisdiction. But it did not, and the court interprets the words as they are. The court may not add a restriction, and reading in subject matter as a limit on jurisdiction would do just that. The Fifth Circuit has recently made this point, noting that Congress's choice of an open-end umbrella term in Section 1631 means the term cannot be pared back to remove some of what it ordinarily encompasses. This makes sense. Jurisdiction may be like a verbal coat of too many colors. This court likes the visual imagery and metaphors, man. But that is the term Congress chose. It will not do for a court to see itself as tidying up Congress's work after the fact by removing some bit here and there on the thought that doing so provides more coherence. Moreover, the Fifth Circuit confirmed its reading by looking to a present-day dictionary which defines jurisdiction, really, as referencing both personal and subject matter sorts. Really? Merriam-Webster's dictionary defines jurisdictions as, really? Seriously? Okay. To be sure, the Supreme Court routinely directs courts to look to contemporary meanings of statute text, and that often involves a lookup of time enactment of dictionaries. You know, I don't normally have a problem with the court consulting dictionaries on something, but if you're a federal district court and you need to look up in a common dictionary what the word jurisdiction means, I have questions about your qualifications, sir. But jurisdiction means roughly the same thing here in 1982 when the law became law. Really? Thanks for clearing that up. Shortly before the statute's enactment, a leading legal dictionary defined jurisdiction, we're still doing this, as a term of large and comprehensive import, generally sweeping the authority in which courts and judicial officers take cognizance of to decide cases. The same dictionary defined want of jurisdiction, the fuller phrase of 1631, as lack of jurisdiction over person or subject matter. Given the clear meaning of jurisdiction, there's no textual reason to think Congress wants Section 1631 to reach only one sort of jurisdiction. Congress chose to use the word subject matter jurisdiction sections. Congress's choice not to use the word subject matter jurisdiction section 1631 is especially telling, given that it's repeatedly used the language elsewhere. I am not inviting this judge to my cocktail parties, guys. And where the legislatures could have, but did not adopt obvious alternative language, natural implication is that they did not intend the alternative, and Congress cannot revisit that choice, and the court cannot revisit that choice. In short, that is the biggest lie of this case. That is the biggest lie. In short, the text of section 1631 is clear and underscores that the statute works to cure all sorts of jurisdictional defects like the kind of issue here, and also those that have no bearing here. This conclusion reflects clear judicial consensus. As alluded to above, the Fifth Circuit, you're still talking. The Fifth Circuit has held the term jurisdiction in Section 1631 encompasses both personal and subject matter jurisdiction. The First, Sixth, and Seventh Circuits have held the same. And the Ninth, 10th, and 11th Circuits have implicitly reached the same conclusion by either applying Section 1631 to a transfer to cure a defect in personal jurisdiction, directing a district court to consider utilizing the provision to rectify a lack of personal jurisdiction, or approving such transfer after it occurred. And though the Third and Eighth Circuits have not answered this question directly, they've said in dicta that a transfer under Section 1631 can cure a lack of personal jurisdiction. Okay. This court holds that Section 1631 can cure personal jurisdiction and not just subject matter jurisdiction. Okay. All right. The previous sections established the court can look to Section 1631 in this case and use it to cure difficulties as to personal jurisdiction. How would that work here? To see the answer, start by looking again at the statutory language and filling in some facts of the case. Kill me. Whenever a civil action, here this habeas case, is filed in a court, the New York court, and this court finds that there was a want of jurisdiction as it did here, the court shall, if it's in the interest of justice as it found, transfer such action to any other court, this court, in which the action could have been brought, and the action shall proceed as if it had been filed in the court to which it was transferred on the date upon which it was actually filed in the court to which it was transferred. That is March 9th, 2025 at 4:40 a.m. Bottom line, Section 1631 means the petition here as treated as if it was backdated. Various Third Circuit cases back up this reading. Consider some below. But I don't want to. I don't want to consider it. The statute was plain on its face. It was how much more authority do I need? How many more cases? In Miller versus United States, the petitioner challenged his discharge from the Army before the Third Circuit and the Federal Circuit. Later, he petitioned the Third Circuit for fees incurred at the Federal Circuit. The Third Circuit held it lacked jurisdiction over the claim for Federal Circuit fees, but by then the deadline to file for fees had passed. But the Third Circuit recognized the Federal Circuit would have jurisdiction over the fee petition had it been filed as an original petition within that court, backdating jurisdiction to the original time of filing. The Third Circuit sent the petition to the Federal Circuit in the interest of justice. A newer Third Circuit case shares the same holding. We need more than one. In Martinez versus Nito versus Attorney General of the United States, a person petitioned the Third Circuit to review decision of the Board of Immigration Appeals. He filed his petition on the last possible day mistakenly in the district court instead of the Court of Appeals. The Third Circuit explained the two criteria of Section 1631 were met. The district court lacked jurisdiction, and a transfer would serve the interest of justice, and therefore assumed jurisdiction over the otherwise time-barred petition, since it would have been able to exercise the jurisdiction on the date the petition was filed in the district court. Like Miller, Martinez Nieto parallels the facts here. A petitioner filed his action in court that lacked jurisdiction. By the time he sought to fix his error, the court could have no longer exercised jurisdiction because of a procedural hurdle. A transfer in the interest of justice cured the problem by backdating jurisdiction. Now I'd like to cite you some other cases. Miller and Martinez are no outliers. Before and after and between them, the Third Circuits have pointed in the same direction. Section 1631 vests the court with precisely jurisdiction it would have had at the original time, and then I'm going to cite a whole bunch of issues. The analysis set out in Part 4 establishes this case, filed in New York on March the 9th at 4:40 in the morning, must be treated as if it was filed in New Jersey on March the 9th at 4:40 under the authority of Section 1631. This establishes the court has had jurisdiction. After all, the petitioner was in custody in New Jersey on March the 9th. The petition must be treated as though it was filed here, and per the Supreme Court, that adds to jurisdiction. But there are two complexities. One, the fact that the petitioner here in New Jersey, when the petition was filed, is now in Louisiana. Jurisdiction may well have been proper in New Jersey on the 9th, but is jurisdiction still proper today, now that the petitioner is no longer in New Jersey? The court's conclusion, yes, for reasons that we're going to tell you about in a minute. I look forward to reading those reasons. The second issue, whether the fact the petitioner is not named as a respondent, either the warden of Louisiana or the warden of New Jersey. That is generally required. Jurisdiction may well have been proper in New Jersey, but is jurisdiction still proper given that he hasn't sued the right person? The court conclusion again, yes, for reasons we're going to tell you about. Take this all up now in the next two parts. I am thrilled. The endo rule. That's what she said? Does that work? The endo rule, that's what she said? Anybody? I know I'm reaching here, but I needed humor. As noted just above, see part 5, this court's jurisdiction is not undone because the petitioner is no longer in New Jersey, having been moved to Louisiana after the petition was filed. The basis for this conclusion is the rule. Call it the endo rule. Do I have to? The habeas court otherwise has jurisdiction over a case, does not lose jurisdiction just because the habeas petitioner has been moved out of the district. Is the rule good law? This part shows that it is. This court moves through the background quickly, that's a lie, by describing the key Supreme Court decisions in this arena and two competing understandings of it, only on which supports the referenced endo rule. Hold on one moment, please. One moment, please. I need, hold on. Let's see if I can find this clip for the humor. This is a long way to try to find a joke. Hold on, it's worth it, I swear.
Debacle.
Hold on. Wait for the joke. Joke time incoming. Hold on. All right. Here we go. All right.
Project Jennifer. Glomar goes after Clementine, the sunken Russian Gulf. 6 feet a minute, that's how fast we pulled her up. And then all of a sudden, blam, her claw breaks in two. The Gulf dangles loose, one sub from another, steel ripping off. Everything we needed, including its nuclear missile, its transmitters, its code books, everything gone. The USS Gudgeon, 1957. 8 Soviet ships caught her, kept her cornered for 4 days. The oxygen depletion, migraines, fainting. Couldn't cook, couldn't light a cigarette.
They smoke in subs?
They used to. The Oklahoma, the Hornet, the Lexington, the CV-2, the USS Wasp. Wasp is a CV-7 out in the Solomon Islands.
Oh, God, I'm sorry. Am I still here?
Yep, that about covers it. Thank you, Mr. President. That about covers it. The court moves through his background quickly, describing the key Supreme Court decision in this area and two competing understandings of it, only one of which supports the reference endo rule. From there, the court explains that any debate there once may have been, now is over. The endo rule is now the law. And under the endo rule, this court, which otherwise has jurisdiction, does not lose that jurisdiction because petitioner was transferred, from New Jersey to Louisiana. Start with key Supreme Court cases. So Endo is a U.S. Supreme Court case, and you called it a rule. That's exciting. Mitsui Endo, an American citizen, was removed from her home and detained in a California relocation center. Oh, good. Oh, good. We're doing Japanese internment again. That's exciting. I'm so glad we brought Japanese internment into this. That was fun. Yes, let's bring the Japanese internment back in this discussion. Holy shit. While confined at the center, she filed a habeas petition in California. The petition was denied. Endo appealed. And while the appeal was pending, she moved out of California into a different facility. This one in Utah. The case went up to the U.S. Supreme Court, which held that Endo should be released. But how? Could the California court issue a habeas corpus relief releasing Endo, even though she'd been moved out of California? The Supreme Court so held. How to understand the Supreme Court's Endo decision? What the fuck? What the fuck? What do you mean? What do you mean? How are we to decide? What do we mean? What do you mean? How are we to understand the Supreme Court's Endo decision? You literally just told us. You just told us. What the fuck? What the fuck? This Japanese citizen, this was an American citizen. This American citizen was in an internment camp in California, and then they weren't. But their habeas petition was filed in California, and the U.S. Supreme Court said, geez, you know what? That's cool because, you know, when she filed for habeas, she was in California. So the fact she's not in California anymore, she can still have her habeas. That's cool. She can file her habeas. And now you want to describe the rule? The Supreme Court just told us the rule. It's the rule. Why do you need to describe it? I already understand it. I don't need more words. Stop talking. On some accounts, the decision was not about California's court power after Ender was ruling to Utah. Who the fuck cares? It was the U.S. Supreme Court. Who cares? Rather, the decision was about where the case would become moot because people were originally named as respondents in the habeas were no longer Endo's immediate custodians. On this ruling, the Supreme Court in Endo held no more and no less. The court was not moot. On that interpretation, Endo defeats any argument in a case in which the habeas petitioner has been moved is not ripe for decision, but does not affirmatively supply a basis for the first court to continue to exercise jurisdiction. What the fuck? There is some language in Endo that supports a mootness-flavored reading, and over the years, some courts have foregrounded the mootness, ripeness aspects of the decision. I'm gonna go back to the West Wing clip. But there is another interpretation of Endo. Well, why not just pick your favorite one? The language seems pretty clear to me. Why are you doing this to me? That reading is true of the Endo court language, stating that the California federal court acquired jurisdiction when Endo filed her habeas and kept the case because the objective of habeas may in no way be impaired or defeated by removal of the prisoner. How is that not clear enough? How is that not just exactly what we're talking about? How much clearer does it need to be? How much clearer does it need to be? The U.S. Supreme Court said the California federal court acquired jurisdiction because Endo was in California when she filed, and then she was moved, but it didn't matter because the objective of the habeas corpus statute may in no way be impaired or defeated by removal of the prisoner. So, I mean, do we need to really keep talking? And the habeas decree of the court can be made effective if respondent who has custody of the prisoner is within reach of the court's process, even though the prisoner has been removed from the district court. And that reading is in keeping with the broader jurisdictional principles. Diversity jurisdiction, for example, locks in at the time the case was filed and survived changing circumstances. Why are you talking to me about diversity jurisdiction? Why do you need to move on to diversity? You have a case. It's about habeas. It's from the U.S. Supreme Court. It deals exactly with this issue. How much more law do you need? That is true as the parties change citizenship. And it's also true as the amounts in controversy. Holy shit. Or take this example. I don't want to take another example. Jurisdiction over an in rem civil forfeiture and admiralty proceedings? How do we bring admiralty law into this? Is generally determined by the physical location of the res, that is, at the moment the case is filed is seized. The res may wind up leaving the physical jurisdiction, maybe it's moved, or maybe it's sold off and the cash goes somewhere else. What then for jurisdiction? The answer, the court that initially kept jurisdiction keeps it. Well, I'm glad you cleared that the fuck up. I'm really glad you cleared that up about dealing with in rem jurisdiction. I wasn't clear enough with the on-point U.S. Supreme Court case. I'm really glad you had some authority dealing with an in rem procedure. That's exciting and fun. Thanks for clearing that up, Jesus. And then in the footnotes, we're going to talk about seizing a vessel just because I want to bring admiralty law into this. So that's great. Let's cite some things about what happens if I seize a boat. Kill me. As alluded to above, there's been a debate over the years as how to most faithfully read endo. I'm not sure how much interpretation you need. It seemed pretty clear to me. But the back and forth is now over. No, it's not. That's a lie. The Supreme Court has made clear that endo is not a mootness case, but has jurisdiction one. Per the court in Pandia, oh my fucking God. You can't be fucking serious. You can't be serious. So there were some people who thought maybe endo meant this, and then there were some people who thought maybe endo meant this. But the U.S. Supreme Court clarified the issue. Couldn't you have just cited that the whole time? Geez, I'm not quite sure what endo means. Some people think it means this. Some other people think it means this. But the U.S. Supreme Court thinks it means this. Geez, which of these interpretations will I go with? It's so hard to tell. It's so hard to tell. Endo stands for the important but limited proposition that when the government moves a habeas petitioner, after she properly files a petition naming her immediate custodian, the district court retains jurisdiction and may direct the writ to any respondent within its jurisdiction. That might have been dicta, but other cases point the same way. The U.S. Supreme Court isn't good enough for me. Shit. Take, for example, Ariba versus Director of Hudson County. There, a person detained in New Jersey filed a habeas. The petition was denied. Transferred to a detention facility outside New Jersey, he made a new filing, which the Third Circuit took as a motion to reconsider the habeas. Could the motion be taken up even though the habeas petitioner was no longer in New Jersey? Yes, the Third Circuit answered, because like in Padilla, it took endo as supporting continued jurisdiction in the habeas even after the habeas petitioner was moved. The Third Circuit cited endo and Padilla, and it noted, our precedent likewise reflects an adherence to the general rule articulated in endo that the government's post-filing transfer of 2241 petitioner out of the court's territorial jurisdiction does not trip the court's jurisdiction over the petition. Well, geez, that seems like really clear language. I don't know that we need anything more clear than this. It's already seemed pretty clear. This is further clear language. And we're not gonna cite anything more, right? We don't need to cite anything more. This is really clear. We're done citing things now. Oh, we're not done citing things. Here's another Third Circuit opinion. N party Cartesino. We do not believe the passing about the body of a petitioner from one custodian to another after a writ of habeas corpus has been applied for it can defeat the jurisdiction of the court to grant or refuse a writ. All this is consistent with other Third Circuit cases. And the district court of this circuit has treated the matter as done and settled. Then why did you spend so much time discussing it? A habeas corpus with the jurisdiction does not lose it because the detainee's been moved out of district. See a whole bunch of cases. It goes on for a goddamn more paragraph. Holy shit. Bottom line, endo was law. I thought that was pretty clear coming from the US Supreme Court. I was of the vague impression that, when the US Supreme Court states something, it's kind of the law of the nation, but apparently that wasn't clear and I needed that clarified some more. Thank you for spending so much time clearing that up. And then also, geez, whatever does it mean? If only we knew. Oh, the US Supreme Court told us. But here's a whole bunch of Third Circuit cases that say the whole same thing. Bottom line, endo is now the law, and under that rule, the court retains jurisdiction, even though they're in Louisiana. Great. Thank you for this very circuitous path to get me where I was several pages ago. I need hazard pay. To this point, the court has determined it's properly acquired jurisdiction because under the relevant statute, which seems pretty clear on its point, the petitioner counts as though it were filed here at 4:40 in the morning on March 9th. And as set out above, jurisdiction has stayed with the court even though the petitioner was moved. There is, of course, one remaining issue. As noted, see parts 2 and 5, habeas petitioners must name as a respondent the detainee's immediate custodian. For a person being detained in connection with immigration, the immediate custodian is the warden. The petitioner did not name any warden. That was no surprise. At the time they put together the filing, petitioner's lawyer thought he was in New York. It would not make sense for them to name the warden now New Jersey. Is this an issue? As a practical matter, not always. When a habeas case is filed in the wrong district and then sent to another, the petitioner often simply adds a proper respondent warden in the new district, and things are wrapped up that way. But that is not required. A court does not have jurisdiction unless the proper immediate custodian is named as a respondent in the petition. A respondent custodian can choose to waive objections to personal jurisdiction, but they don't need to. That is the essence the respondents take here. First, they argue the court lacks jurisdiction because the petitioner's current immediate custodian, the warrant of Louisiana, is not named as a respondent. And this might be a practical problem. There are hard territorial limits on a habeas court's jurisdiction. This court's habeas power ends at the state line. Outside long-arm jurisdiction is available in most other civil cases, but not this one. So if a Louisiana warden must be named, the court might not be able to reach him or her. And second, the respondents argue that even if the petition were treated as if being filed on March 9th, there's no jurisdiction here because the New Jersey warden was never named. Neither of these arguments work. The first argument as to Louisiana's warden runs aground of the Supreme Court endos rule. I mean, it seemed like it. It seemed like exactly that. It seemed like the Supreme Court said almost exactly that in exactly those words. Literally exactly those words. So, yes, you do get to exercise jurisdiction outside your territory. But we're going to keep talking about it for a while. The second argument as to the New Jersey warden makes for a closer question, but two does not work in light of the unknown custodian exception most commonly associated with Judge Bork's decision in the DC Circuit. This is explained in Part 7B. The Louisiana warden. Recall that under the endo rule, a court retains jurisdiction over habeas, even if the petitioner is moved out of the court's territory. But how can this work? Assume that the court decides that the petitioner must be released. The court would then be expected in the ordinary case to issue a writ to the prisoner's immediate custodian. But the court does not have obvious direct power over the custodian. After all, in the endo situation, the immediate custodian is by definition outside the court's jurisdiction. Something needs to give. Either the endo idea that the court keeps jurisdiction as the petitioner is moved about, or the idea that habeas rates can only run to the immediate custodian. The Supreme Court has made the choice. So that seems to clear that up. Per Padilla, endo stands for the proposition that when the government moves a habeas petitioner after she's properly filed a petition naming her immediate custodian, district court retains jurisdiction and may direct the writ to any respondent within its jurisdiction who has legal authority to effectuate the prisoner's release. Who has legal authority? A senior supervisor of the immediate custodian. For example, in the Endo case itself, the California court did not have power over Endo's Utah-based immediate custodian, but that did not matter, the Supreme Court explained. The California court had jurisdiction over the up-the-chain supervisor of the immediate custodian, and that supervisor could tell their immediate release. Come back now to this case. Here, there's no need for the petitioner to have named Louisiana warden. That's because one of the warden's senior supervisors is named, and that's what's needed under the Supreme Court petition. The senior supervisor respondent is the Secretary of Homeland Security, and ICE runs the facility. Moreover, as respondents concede, the Secretary is within the court's jurisdiction. Thanks for clearing that up. Right? Thanks for clearing that up. Holy shit. Come now to the final immediate custodian issue. The petition, as discussed above, was filed in New York on March the 9th and must be treated as though it was filed in New Jersey at that moment. I know. I'm painfully aware. Can we go back to looking at watches? Is it too late for me to just become a watchmaker? I mean, I'm just saying. I have a dream, and that dream is me making watches. Is Rolex or Tudor or somebody hiring? I'm willing to move overseas. Can I get an immigration visa to Switzerland or something? Asking for a friend. Any of you guys live in Switzerland? Can I crash at your place? That seems to run afoul. First glance to run afoul of the immediate custodian role. After all, jurisdiction requires not only the petitioner being the district, but also his immediate custodian being named as respondent on the petition. And here, no New Jersey warden was named. The court concludes that on the facts here, this is no bar. To explain why, the court first sets out some relevant and uncontested facts, and then describes the unknown custodian exception to the immediate custodian rule. The court then determines that the exception applies to this case and excuses petitioner's failure to name the New Jersey warden. Move now through some relevant facts. The petitioner, as previously noted, was arrested around 8:30 p.m. on March the 8th. The arrest took place in Manhattan. I know. One of the arresting agents said to the petitioner's wife that he was being taken to a particular and prominent local building. A lawyer for the petitioner then worked all night to draft a habeas. It was electronically filed at 4:40 in the morning. It's pretty fast work, right? From 8:30, he was arrested at 8:30, and the lawyer's filing a petition at 4:40 in the morning. That's ballin', man. Why there? Per the lawyer. At the time filing the petitioner, we had every reason to believe that Mahmoud, the petitioner, was detained in New York because of what the DHS agent told his wife and the ICE online detainer location system. I originally checked the ICE locator around 10 p.m. on Saturday, March 8th, and Mahmoud was not in the system. I checked around again at 1:35 in the morning and said he was in custody in New York and to call the field office. I checked again at 4:29 on Sunday and said the same thing. I checked around at 8:30 in the morning and it was still listed as being detained in New York. In a nutshell, petitioner filed the petition because affirmatively supplied information said he was there. The arresting agent pointed to Manhattan, and so did the online detainee locator. It located the petitioner within New York, both before and after the filing was made there. But as been discussed, the petitioner was moved from Manhattan to New Jersey during the early hours of March 9th, about 80 minutes before the Manhattan petition was filed. Could the petitioner have told his lawyer or someone else that he'd been moved to New Jersey? The evidence on this point from the petitioner has not been disputed. The moment I arrived in New Jersey, I told the officers I needed to call my attorney. They told me to ask another guy at the facility. I asked that guy, and he said I need to wait till I was processed. Later in the morning, I asked a female officer to allow me to call my attorney, and she told me, like the first guy, to wait until I was processed. Could someone have determined in real time that petitioner had been moved to New Jersey, such that the petition then being prepared might have been listed a New Jersey warrant as respondent? Nothing in the record suggests that, and there's no suggestion that anyone connected with petitioner was sitting on their hands. The lawyer worked through the night on the habeas petition and rechecked the detainee locator 10 minutes before the filing. Per wife's declaration, I was unable to sleep that night, first working with Amy, the lawyer, Hala Amy, to secure immigration counsel for Mahmoud, and then trying to find a way to make contact. The fact you were able to find a lawyer for this guy at 9 o'clock at night is amazing. How did you do that? The lawyers relayed to me that he seemed to be in Manhattan through the night, according to ICE. By the early morning, they had filed a lawsuit in federal court with my consent. Within a few hours and still early morning, the location showed Mahmoud as being in the immigration center in Elizabeth, New Jersey. I immediately went there, desperate to see my husband. I attempted to see him twice and was told by the employees of the facility he was not there and I'd not be able to see him. I waited outside the facility for approximately 2 hours and was never able to see or be in contact with Mahmoud. Holy shit. Based on undisputed evidence here, the court finds as of the time she filed the petition, petitioner's lawyer had been affirmatively and persistently led to believe he was in Manhattan, that she relied on that information, and in spite of her best efforts, there was no realistic way for her to know petitioner was in fact in New Jersey. All this leads, all but necessarily, to another finding. As of the time she filed the petition, there was no real way for petitioner's lawyer to know that at that moment, they were in the immediate custodian of New Jersey. After all, there was no way for them to know he was in New Jersey. Situations like this above are rare. A lawyer for a person in custody can almost always name the detainee's immediate custodian, but not always, and that's where the unknown custodian exception to the immediate custodian rule kicks in. Take it up here. The unknown custodian exception is often associated with Judge Bork, who issued a relevant in-chambers opinion. In federal custody and soon to be extradited, the petitioner applied for a habeas, but the United States declined to say where he was, what to do, how to satisfy the immediate custodian rule when there's no sense of where the detainee is. In these circumstances, Judge Bork held the habeas petition before him could be assessed on the merits. It was more of a practical solution, Judge Bork ruled. This even though it was at odds with the district confinement rule, of which more soon, because it was anyone's guess where the petitioner was in D.C., where Judge Bork sat. And even though this was at odds with the immediate custodian rule, for the same reason. Given the immediate custodian was unknown, Judge Bork relaxed the immediate custodian rule and allowed the Attorney General to be named as respondent on the habeas petition on the theory the Attorney General was the ultimate supervisor of the immediate custodian, whoever that custodian turned out to be. That, in a nutshell, is what the unknown exception does. It creates an exception to the otherwise applicable immediate custodian rule when, on the facts of the case, the immediate custodian cannot be known. Is this rule the law of the land? The Supreme Court opinion suggests the answer is yes. Oh, good. In Padilla, Chief Justice Rehnquist wrote for 5 justices. 2 of those justices in concurrence proposed an exception to the immediate custodian rule. The Chief Justice rejected the exception. No exceptions to the rule, either recognized or proposed, apply here. The proposed exception was clearly the one offered by 2 concurring justices the Chief Justice cited. But what were the recognized exceptions? The Chief Justice's opinion suggests 2, and each laid out in a footnote. That footnote reads as part. And then the footnote cites the Judge Bork case that we just read. So the majority opinion in a footnote, the majority opinion says there's some exceptions, and then in a footnote cites Judge Bork's opinion as an exception. So we're done here, right? We're done and we can stop talking now, right? Right? And then another point in the opinion, the Chief Justice explained that on the facts of the Padilla case itself, the identity of the immediate custodian was not shrouded in secrecy. All this suggests that the Padilla majority took Judge Bork's unknown custodian exception as a part of law. After all, as far as proposed and recognized exceptions went, the unknown custodian exception was on the recognized side of the line, and the Padilla court took the exception as a given, while the facts of the case to be measured against it. The United States has generally taken the same approach. When the issues coming up around the country, it's argued the unknown custodian exception does not match the facts of those particular cases. But it does not appear to have contend the unknown custodian exception is in some self incorrect. Lower courts' opinion have also treated it as correct. Kill me.
The USS Wasp. Wasp is a CV-7 out in the Solomon Islands.
Oh, God, I'm sorry. Am I still here?
Lower court's opinions often treat the unknown custodian rule as part of our basic law. United States versus Masao, for example, defendants sought access to a trial witness held in military custody via writ of habeas corpus ad tested. What the fuck is this phrase? What the fuck kind of bullshit Latin bullshit phrase is this? What the fuck? Ad test of facidum is Latin term meaning to testify. It refers to a legal order, often a subpoena, that requires a person to appear in court to a proceeding. Isn't it just a subpoena? It's a subpoena for testimony. I gotta go. I got it. Okay, pressing on. I've never seen that phrase before ever. No matter the First Circuit, Fourth Circuit held, the immediate custodian was unknown. Under such circumstances, the writ is properly served on the prisoner's ultimate custodian. The ultimate custodian in Judge Bork's case was the Attorney General, who supervised all federal prisons to which the habeas prisoner might have been held. In Massau, the ultimate custodian was the Secretary of Defense, who supervised all nations' troops, some of whom were been said to holding the witnesses. The case does not stand alone. Oh, good, more cases. In United States versus Park Cha, the court came to the same conclusion on virtually the same fact. Witnesses were said to be in the custody of the United States in an undisclosed location abroad. Could the habeas writ issue for their testimony? Yes, the court held, citing the unknown custodian rule, because the immediate custodian of the unknown writ may be properly served on the prisoner's ultimate custodian, and so it was served on the Secretary of Defense. In another example, in Alley versus Ashcroft, habeas class action named the Attorney General's respondent. What about the immediate custodian rule? Per the district court, this did not matter. A nationwide habeas class with the Attorney General's respondent is appropriate where the location of the putative class members is unclear. In dicta, lower federal courts have consistently embraced the unknown custodian rule to the immediate custodian rule, citing a whole bunch of cases. And the standard treatise has put it this way. The immediate custodian rule is inapplicable where the prisoner's current whereabouts are unknown, applying the unknown custodian exception. The unknown custodian exception is an established part of federal law, and under the immediate custodian rule, it can be set aside in limited and special circumstances. Which ones? When the identity of the immediate custodian is virtually unknowable. That was the case here. The petitioner's lawyer, the court found, was affirmatively led to believe he was in New York, and because no phone calls were allowed, the petitioners could not undo the impression. What happens when the unknown custodian exception applies? The petitioner is permitted to name not his immediate custodian as normally required, but his ultimate custodian. And that's what petitioner did here. His petition filed on March 9th named his respondent the Secretary of the Department of Homeland Security. She's the ultimate supervisor of any possible warden. All this adds up to the conclusion that the respondent's New Jersey-focused immediate custodian argument is not persuasive. The petitioner did not name the respondent as immediate New Jersey custodian, but he did not need to. The custodian was not only unknown to petitioner's lawyer, but virtually unknowable. And so the petitioner could clear the bar by doing what they did, naming petitioner's ultimate custodian the Secretary of Homeland Security. Take now these 3 points related to the above conclusion, each rooted in comparison. But why? I think you already sold me. Why are we still talking? I was convinced. I was still convinced. Why are you telling me these things? Why are you telling me? The first point, in some ways, this is an easier case for application of the unknown custodian rule than the prior case, given where this case is procedurally and that one was. To see the point, note that the federal habeas court exercises a package of powers. The power to entertain a prisoner's request that the courts direct a habeas release to the custodian is one of these powers. Another power typically comes into play later, the power to issue a habeas writ instructing a custodian to produce the body and justify detention. Judge Bork used an unknown custodian rule through the end of the case at the merit stage. But this case is at a much earlier point. All that's in play for now is the table setting question. The court's power to entertain a prisoner's request, the court direct a habeas writ to the custodian. And at this earlier point in the litigation, there's more flexibility in terms of the petitioner naming the correct custodian. The habeas statute, for example, is cleaved in two. Section 2243 covers the later stages of habeas on merits. 2242 covers the earlier stage, which is essentially pleading where this case is now. In turn, 2242 is more forgiving when it comes to naming precisely the right custodian. Section 2243, which kicks in later, has known if known carve out. Judge Bork has noted, I guess this person's really a fan of Judge Bork, I guess. Judge Bork has noted, applied the unknown custodian exception to what was the last stage of the habeas proceeding. He ruled in the merits of the habeas proceeding before him, but even at that point, no immediate custodian had been named. It's a light lift to that applied the unknown custodian exception to the case now. At the beginning of the habeas process, when Congress had suggested, through if known language, something of a different approach to the unknown issues. Okay. Turn now to another reason why it's more straightforward to apply the unknown custodian exception in this case than the prior case law. To see that point, first take a step back. The law often channels cases to particular courts based on fixed and advanced criteria, like where an event took place or where a defendant lives. Applying pre-baked rules of this sort has numerous effects, including paring back on forum shopping. Habeas law is no exception. It too has rules that send certain habeas cases to certain courts, and limit foreign shopping is also a key purpose of the rules. The rules are reflected in Congress's 1867 amendment to the habeas statute, under which the district courts have power to grant habeas, but only within their respective jurisdiction. Congress, per the Supreme Court, thought it inconvenient, potentially embarrassing, certainly expensive, and on the whole quite unnecessary to provide every judge anywhere with authority to issue the Great Writ on behalf of applicants far distantly removed from the courts where they sit. Judicial practice reflects the same concerns, and courts have long held that habeas writs cannot typically issue from where the person in custody outside the borders of the district in which the habeas person sits. In the mid-20th century, the Supreme Court began to refer to this approach in shorthand as to the district of confinement rule. The district of confinement rule is this: for habeas petitions challenging the present physical confinement, jurisdiction lies in only one district, the district of confinement. But this line can be hard to hold. Habeas is a remedy that runs to the defendant's custodian on the theory that's the custodian who can release the detainee if were to do so. And that can fold complexity into the mix. Sometimes, for example, a person might be detained in District A while the custodian is both in District A and District B. This might be the case where the custodian is physically in District A, but exercises power in both District A and District B. Does that mean the case can only go forward in both the districts, and also one of the districts where the custodian is located? Does the background district confinement rule get overridden or softened? What? Or take another example. Think of a federal criminal procedure held in prison in District A under the authority of the Attorney General, as in some sense all or virtually all federal criminal prisoners are. Can the habeas case go forward only in District A because that's the district of confinement, or can go forward in any of the court's 94 judicial districts that they pick? All this points to habeas law core challenges in this area to prevent the district of confinement rule from being undermined by the fact that habeas cases must also be run against the custodian. A critical part of the Supreme Court's approach to this issue has been adopted by the immediate custodian rule. That rule tells habeas petitioners to name nearby officials. In a habeas challenge to present physical confinement, the district of confinement is synonymous with the district court that has territorial jurisdiction over the proper respondent. That's because the immediate custodian rule applies. By definition, the immediate custodian and prisoners reside in the same district. Whenever a 2241 habeas petitioner seeks to challenge his physical custody within the United States, he should name his warden as respondent and file the petition in his district of confinement. That rule, derived from the terms of habeas, serves the important purpose of preventing forum shopping by habeas petitioners. Without it, the prisoner could name a high-level supervisory official as respondent and then sue that person wherever he's amenable to long-arm jurisdiction. The result would be rampant forum shopping, district courts with overlapping jurisdiction, and the very inconvenience, expense, and embarrassment to which Congress sought to avoid this when add the jurisdictional limitation 137 years ago. 137 years ago is when I started reading this case. The immediate custodian rule, in short, checks all the boxes. It tells the habeas petitioner who to sue, the immediate custodian, and zeroing in on the immediate custodian prevents any possible end run around the district court's confinement because the immediate custodian is always in the same district where the prisoner is confined. Put differently, the immediate custodian rule eases the possible tension between overarching district confinement and the idea that all habeas petitioners must name a custodian. The reason is that under an immediate custodian rule, these two point in the same jurisdiction. Why? Can we impeach this judge? Not because the judge is reasoning, not because I disagree with the judge, but because their writing sucks. Can we impeach the judge? Or get them an editor or something? Please. Against this backdrop set out above, come back to the law and then this case. In the law, Judge Bork relaxed the immediate custodian rule because the custodian was unknown. But in doing so, the case was an especially large leap. That was because in that case, relaxing the immediate custodian rule, vying unknown custodian exception, potentially threatened to undermine one of the key reasons the immediate custodian rule is there in the first place, to prevent habeas petitioners from going forward in a place that's not the district of confinement. After all, the petition was filed before Judge Bork in Washington, D.C., but the petitioner may not have been confined there. When he was being held where he was being held was unknown to the court. He could just as been easily in custody in Texas or Michigan or Maine. And a federal judge in America might have been asked to use the unknown custodian exception to get to the merits, just as Judge Bork was asked to do. But this case poses none of the issues. This case is filed on March 9th at 4:40 in the morning, can go forward to New Jersey because that was where the petitioner was confined to. And because New Jersey was the only district of confinement then, this case could go forward only in New Jersey unless it's now dismissed and refiled elsewhere. That means that the relaxing the immediate custodian rule here, because of time of filing on March 9th, the petitioner's lawyer could not have known the petitioner was in New Jersey, does not open the door to forum shopping. The cases filed can go forward only here. The other three districts where the petitioner was nowhere to be found are out of the question. Indeed, relaxing the immediate custodian rule here has precisely the opposite effect of forum shopping. It opens the way for this case to continue in this district that was the single district of confinement at the moment the petition was filed. The unknown custodian exception does this by removing the impediment to the case going forward in New Jersey. The district of 199 from Bear Jews. Love the watch. Let's see it. Thank you. To put it a different way, per the Supreme Court, the immediate custodian rule exists in part to protect the district of confinement rule. If the unknown custodian exception to the immediate custodian rule makes sense, even where it seems to undermine the district of confinement rule, that's all the stronger case for applying the unknown custodian rule here. Why? Because applying the unknown custodian rule in this case actively advances the district of confinement rule. Applying the exception here ensures the case goes forward in the district of confinement, New Jersey, where the petitioner was held. If the unknown custodian exception can apply, even in teeth of the district confinement rule, why not apply it here where it's the rule? Conclusion. Thank God. The unknown custodian rule applies here. And it's important in ways to make sense to apply the exception in the case than it did in the prior case. In other sense, though, the prior case was stronger and easier for that application of the unknown custodian. That's the subject of this section. Really? Seriously? Per the Supreme Court, courts must apply the habeas statute with an eye towards the underlying equitable nature of the writ. And as apparent in the prior case, that as the unknown custodian exception were not brought to bear, no habeas petition could have been brought anywhere in the United States, save perhaps by a Supreme Court justice. Okay. After all, the location of the petitioner was kept confidential. No proper custodian could be named anywhere because no custodian could be named. And this would have been as much problem for the habeas petition filed in DC where it was brought as anywhere else. From an equitable perspective, this suggests the prior case was a more persuasive case for application of the unknown custodian exception. Without that exception, the case could not have gone forward anywhere. But this case, without the exception, can simply be dismissed and refiled in Louisiana. To unpack the point a bit more, in the prior case, it was unknown custodian was the last resort. It was applied and the case was considered. But if the exception was not applied, there had been no way for the petitioner to seek habeas relief, not in Washington, D.C., and nowhere else. Without leaning on the unknown custodian exception, there could have been no habeas. Here, things are different. I know you just told me. If the unknown custodian rule is not applied here, the case might arguably need to be dismissed, but so the habeas can still be presented. The petitioner is now detained in Louisiana and can presumably refile the habeas there. In that sense, and it's plainly an important one, this case is less compelling one for the application of the unknown custodian rule. That point moves the needle, but not far enough. On balance, the court's judgment is the same. First, an exception applies on its face, while the associated with the prior case, the exception is bigger than just this case. Second, applying that exception here is generally consistent with the habeas statute. And third, on the facts of this particular case, the unknown custodian exception vindicates the district a confinement rule, and in that sense protects against forum shopping. All that weighs heavily. Moreover, applying the unknown custodian exception in this case is in the interest of equitable concerns. The Supreme Court has long invoked habeas. If the unknown custodian exception does not apply here, and this case is therefore dismissed, it's true the petition can be refiled in another federal court. But it's also true that the exception does not apply and the case is dismissed on that basis. The implication would be that for the period of time during which the petitioner is arrested in the United States and then moved by federal officials, during which no habeas court would have the power to hear him, even though as here his lawyers and families cannot determine where he is, only because they've been inaccurate information and because he's not been allowed to correct that information by making a phone call. A detainee in that situation would not be able to file a habeas petition in the original place of confinement because he's no longer there. And without the benefit of the unknown custodian exception, he might not be able to find a habeas petition in the place where he was moved because where he filed in the first location, he did not name his second custodian. Looking back from that perspective today, that may not seem like very much. The petitioner is now in Louisiana. He can file the habeas petitioner there, but it's not the only perspective. 4 more pages. I can make it. 4 more pages. We can do it together, chat. You and I. We're a team. We're a team, guys. Let's build our spirits together. Let's build our spirits together and rally. Let's rally. We can do this. Let's rally together and we can bring it home. We can do it. We can do it. We can do it. We can do it. All right, 4 more pages, people. We can go. All right, great. The implication of not applying the unknown custodian exception here is that as of March 9th, detainees in the United States would not have been able to call on any habeas court, not in Louisiana, New York, or New Jersey, and not anywhere else either. That is too far. Our tradition is not there's no gap in the fact that the habeas, no place, no memo, no person where held in custody cannot call in a court. Conclusion and next steps. Wasn't the previous section also called conclusion? I'm pretty sure the previous section was also called conclusion. Do you like conclusions? I've got a conclusion for your conclusion. I've got a conclusion for your conclusion, baby. It's okay. $9.99 from Stephen Light. We're confident you can handle the anchor lag of this relay. Yeah. The court's conclusion: Ed jurisdiction over this case and response motion to dismiss must therefore be denied. Recall for a moment the basis for this conclusion. A habeas court generally has jurisdiction where the habeas petitioner is physically in the court's jurisdiction where he files the habeas. Here, each box is checked. The petitioner was in New Jersey on March 9th at 4:40, and Congress required the petitioner must have been filed in New Jersey at that same time. That vested the court with jurisdiction. The court's jurisdiction is not defeated by petitioner having been moved to Louisiana, and the court's jurisdiction is not undone either by petitioner have not named Louisiana or New Jersey. Before concluding, you promised me though. You promised me it was the conclusion section. I remember. You wrote the word conclusion. You wrote it twice. What do you mean before concluding? What do you mean before concluding? You promised. You promised. You can't take it back. You can't take it back. Before concluding, knowing that this court is postured in an unreasonable, unusual way, but in rare circumstances, other courts have dealt with a case that in some ways has similar facts to this one. In such a case, a habeas petition is filed in place 1, where petitioner is actually in place 2, and by the time the court sends the court to place 2, the petitioner's been moved to place 3. These cases all landed on the same conclusion in this case. Jurisdiction is proper in place 2. In the ordinary course, the court's decision today would likely be unappealable, but there may be reasons for allowing interlocutory appeal here. The courts will solicit the parties' view on the question, but discussion about an interlocutory appeal may turn out to be unnecessary. The response, for example, may opt to waive their right to further challenge the court's jurisdiction and venue. At that point, the court will solicit the response view. It will do so shortly. For reasons set forth above, response motion dismissed is denied. It is on this first day of April 2025, so ordered. Michael Fabrice, United States District Judge. We did it. We did it. We did it. We reached the end. But at what cost? But at what cost? It's over. It's over. All right, let me see what's going on in chat. Let's see what's going on in chat. See if there's anything I want to respond to. Holy shit. We're all gonna need therapy, says Jen. I need some therapy. Senate needs to get to work and pass a law. Anytime Senate wants to pass a law would be fine. This is kind of like why the public has a problem with lawyers and judges. Seems like they're just making up law. Well, no, they're not. They're not making up law. They were just incredibly long-winded. The judge didn't make up any law. He was just incredibly verbose. Yeah. New York Real Days and this is a case where he omitted information on the visa. That's not the basis for which that's not the basis on which the U.S. government is seeking to deport him. So that is relevant at this time as to whether or not he lied on his green card. The only basis at which the United States government is seeking to remove him at this time is the basis that the Secretary of State has unilateral power to determine that he is contrary to our foreign policy goals or harmful to our foreign policy relations. I forget the exact wording of the statute, but that's the only basis. So whether or not he lied in his green card is irrelevant. Whether or not he committed a crime is irrelevant. All those things are irrelevant because the only basis at the moment is the Secretary of State's supposed unilateral, unquestioned power to remove him because reasons. So that's the only basis we can consider because it's the only basis that is going on. So nothing else matters. Anyone can see nothing really matters. Nothing really matters to me. Those talking about marriage and possible green card fraud, that's not the issue. That is not the issue. That's not the basis of the deportation. So it's irrelevant. Anything else? Something about doves deciding cases. That's pretty funny. All right. All right. I don't see anything else among member chats at the moment. So we are done with this stream. I do appreciate the 270 of you who are here. Just a friendly reminder that as of Tuesday or so, we're going to be daily streaming the Karen Reid trial. So I hope you turn in for that. It probably won't be as dense as this, hopefully. So we can look forward to having fun. Hopefully. Again. All right. I saw your email. I'm probably unlikely to be able to attend. I can't just like pop into South Carolina, but I did see your email. Thank you for the email anyway. I'm at $5 from Joss H. What's happening is in the United States is literally 1930s German shit. What the fuck? I mean, I don't understand your question. We just do legal analysis over here. That's all we do over here. I don't understand. I don't understand your question. We just stick to the law, baby. That's what we do. I've been Uncivil Law Man. Until later, I hope all is well. Cheers from now, my friends, and goodbye.